Right. Well, thank you.
For an opening.
Exactly. Well, it's a pleasure to be here. I really appreciate the invitation to talk to you all. I've actually been, it's been a struggle just to keep up with all the new developments, unfortunately, over the last few months. And my colleagues and I are getting constant media calls by journalists who are struggling also to keep up on everything that's going on. And so I suppose the good news about this talk is that I really have been doing my best to keep up on a lot of different efforts. And for better or worse, the legal landscape is crucially important to understanding the impact of some of the initiatives in the new administration. And so I know that you all don't have a law background. I expect most or all of you have a science background or other types of technical background and or social sciences. So this will be pitched at a pretty high level, not assuming that you have legal knowledge, but I'm sure that you know more than I do about some of the technical issues. So I'm going to start with something very basic. You might have learned in your high school government class. Congress makes the laws. It's not actually that simple. We have a long tradition of common law in this country where courts actually do make law, but where Congress makes a law, Congress is in charge. And what Congress does when it makes laws is it often delegates authority to the executive branch, the president and executive agencies. And this is of crucial importance in environmental and natural resource policy and management because Congress very rarely makes detailed decisions about environmental and natural resources and health-related issues. Instead, it empowers federal agencies to do those things. And so we have an array of agencies, including obviously the Environmental Protection Agency, but also the agencies that manage federal lands, the Department of Interior's Bureau of Land Management, the Department of Interior's National Park Service, the Department of Agriculture's Forest Service, that play an important role, for example, in managing the extraction of resources, including fossil fuels from federal lands, among other things. So we have a really wide variety of agencies. I'm going to focus mostly, but not entirely, on work that's situated within the Environmental Protection Agency, but I'm also going to cover some issues related to federal lands and natural resources. And I'll also say, if you all are welcome to interrupt me at any time, if you have a question, I'd love to have some dialogue. I do have a presentation, but don't let the fact that I have slides stop you from asking questions in the middle. I may not get through everything because time is relatively short, but I think that's okay. So another really important point is that agencies' authorities are bounded by the delegation of authority from Congress. It's a really important principle that the EPA and the President and the Department of Interior can only do the things that Congress gave them the power to do, and Congress can give or take away that power. And our laws are structured in such a way that sometimes they're quite detailed, but often they're ambiguous. They're ambiguous sometimes on purpose because they're the product of negotiation between political parties and Congress. And sometimes, even if a law was intended to have a very precise purpose, in a particular application of that law, it might turn out that there's a lot of ambiguity about how it applies or whether it applies. And we'll see some examples of that in this talk. And the important piece of that is that the boundaries of where agencies are allowed to act are often contested, and that creates opportunities for people to challenge agency action in the courts. Most federal laws have a citizen suit provision, and we also have a law called the Federal Administrative Procedure Act that requires agencies to exercise their discretion in specific ways and to follow specific procedures. And so when you hear about people challenging the government's action in court, the administration's actions in court, whether that's about an environmental action or an immigration action or whatever else, typically what we're talking about is somebody who decides that they not only don't like a law but are adversely affected by an agency action, suing the agency to say you actually don't have the right, you don't have the power to do this. And that's true throughout federal agency law and specifically in environmental laws. It's also the case that government agencies have to, the Administrative Procedure Act says that an agency can't act arbitrarily, capriciously, or contrary to law. That means it has to follow the procedures in the statutes. It means it can't go beyond what Congress has delegated to it. It's allowed to interpret what an ambiguous provision means, and courts give a lot of deference to an agency's interpretation of that, but they can't go further than that. But it also means that agencies actually have to have a factual basis for the determinations they make. So if the agency has the authority, for example, to set the maximum concentration of ozone in the ambient air, the agency can't say, okay, we're going to flip a coin, heads it's going to be 65, tails it's going to be 70. That's an extreme example of arbitrariness. But it's also true that the agency can't, for example, act in a way that's contrary to every bit of evidence in the record in front of it. That would also be considered arbitrary because the agency would be making a decision based on factors it's not supposed to consider, or based on factual inaccuracies. For better or worse, there are often disputes in the record, and when there's a rulemaking, there's a lot of scientific uncertainty, and often agencies exercise a lot of discretion because it's very difficult for courts, and courts typically don't like to interpret to make determinations based on their interpretation of scientific uncertainty. And that both often empowers agencies to regulate in a way that might be stricter than industries want them to regulate, but it also often might empower agencies to regulate less stringently in ways that people who want to protect public health don't like, where there are ambiguities in the scientific record or scientific uncertainty. And that's an important principle to keep in mind through all of this. So state governments have a similar structure, not the same structure, but I wanted to start with that overarching picture. So I'm going to start talking a little bit about the Clean Air Act and air quality. So the Clean Air Act, have any of you dealt with the Clean Air Act before? Figures. So the way the Clean Air Act operates, it does a couple of things. It requires the setting of what's called ambient air quality standards. And that means essentially that the EPA is saying that it is not okay anywhere in the country for there to be more than a particular concentration of a specific pollutant. And that's expressed typically as a number. And that number is then something that gets implemented in different ways throughout the country, theoretically at least, to ensure that nowhere in the country will ambient air exceed that concentration. And those standards are supposed to be set in a health-based way. The statute requires it to be set at a level requisite to protect public health with an adequate margin of safety. This is a good example of ambiguous statutory language that an agency can interpret in multiple ways. What does it mean to be adequate to protect public health? What does it mean to be for there to be an adequate margin of safety? And courts have given a lot of deference to the way EPA interprets that. One of the major ways in which air quality is improved in order to meet ambient air quality standards, and there are only 6 pollutants that are covered by ambient air quality standards, but they're important ones. They include, for example, ground level ozone, they include oxides of nitrogen, they include particulate matter, including PM 2.5, very fine particulate matter. And so those ambient air quality standards have to be implemented somehow to actually protect the air. And they're implemented mostly through what we call emission standards. And that means that any particular source, a factory, for example, can't have more than a certain amount of a pollutant going out of its smokestack into the air. And if you succeed in creating emission standards and implementing and enforcing those emission standards, hopefully the ambient air quality will start to improve as a result of that. We have both stationary sources like factories, but also mobile sources, cars, trucks, and buses that emit pollutants, and there are different ways of controlling both of those pollutants. The pollutants that are covered under the ambient air quality standards are called criteria pollutants for obscure reasons, but there are also pollutants called hazardous or toxic air pollutants, and those tend to not be the types of pollutants that you see spreading throughout an entire basin, but have particularly bad effects concentrated in a particular area, and those are regulated differently. The EPA historically has not done as good a job at regulating hazardous and toxic air pollutants as it's done with criteria pollutants. what are we here to talk about? Well, what's happening in the new administration. And so I'll now get to the first examples of that, which are some potential rollbacks in the new administration. So we, quite recently, I think in 2015, the ground level ozone standard ambient air quality standard was adjusted by EPA to a level of, what was the adjustment to? It was to 65, I believe it was 65 parts per billion. And that adjustment was the result of or was it 70? 70. It wasn't 75. It was adjusted to, I think it was just downward by 5. I'm sorry. I think it was adjusted to 70. And the public health advocates wanted that adjustment to be more significant, down to 65. And in fact, EPA's own Science Advisory Board wanted it adjusted down to that level of 65. But EPA made a judgment that the 70 level was good enough. And even though there had been a lot of opposition to it, the public health and environmental groups didn't challenge it because it was a significant improvement over the prior standard of 75. And that change was something that they saw, they see it as being incremental change that will be helpful over time. That's being challenged by industry groups in court, and it seems likely that the Trump administration is going to decline to defend that in court or to try to find some way of getting out of their new standard. And it's also possible that they would even go back and do a new rulemaking and try to set the standard again at a less protective level. If they did that, they would get sued by the environmental community. And again, based on the record, the EPA could have made the standard stricter than they did. And so, the question will be how much deference would courts show to the EPA making a decision to roll back the standards further in some way. There is this oddity of the government potentially not defending its own rules from a prior administration. And we see that a lot. We see it often with changes from administration to administration when there's a change in political party, where the government can rethink its policies and make a different decision. The question is, will that different decision actually violate the law because it's not supported by an adequate factual basis? Or will it otherwise be challengeable legally? But the president does have the authority within legal limitations to change the policy judgments that the agencies make. And so we can expect to see changes in, for example, ambient air quality standards. We see a similar dynamic with the mercury and air toxics emission standards. These standards were also issued recently. They've been through various rounds in the courts, and this is another example where the rule is being challenged now by industry groups, and the administration is looking at it to see if they really want to continue to defend the rule or if they're going to try not to defend it. So the last one, which is crucially important right now, is greenhouse gas emission standards. It is fairly new territory for the federal government to be taking a role in regulating the greenhouse gas emissions that cause climate change. Greenhouse gas emissions were not something that Congress was thinking about when it passed the Clean Air Act in 1970. It's fair to say that until probably the early 2000s, no one in the federal government took seriously the idea that greenhouse gases would be covered under the Clean Air Act. But pretty early on in the Bush administration, in the early 2000s, staff at EPA began to realize that that was something that would be necessary to do. The George W. Bush administration declined to do it. There was a very famous court decision by the Supreme Court called Massachusetts versus EPA, where the Supreme Court said, yes, greenhouse gases are a pollutant, and you have to figure out if they cause an endangerment to public health and welfare, and if they do, the EPA has to regulate it. That happened towards the end of the Bush administration. It was followed by some stalling. In the Obama administration, over time, the federal government began to regulate greenhouse gas emissions through the Clean Air Act for the first time, establishing in various ways emissions standards that help to reduce greenhouse gas emissions. Those are, I would say, of all of the different environmental initiatives, probably the ones that are most at risk right now under the new administration. It's very clear that this administration isn't, doesn't believe that we ought to be working to address climate change through greenhouse gas emissions reductions.
So, going back to the case of the ozone ambient air quality standard, if the federal government declines to defend a suit brought by industry, would the standard, would they just rescind that adjustment, or would it automatically rescind to the old standard?
Yeah.
And then is that action to, whatever the action is, if it's just to decline to defend, to de facto make it the old standard without going through the whole regulatory process, is that an action that would be subject to potential lawsuit by environmental?
Okay, so there's a great question. So there's a lot of questions embedded in that, and I'm going to try to answer at least the ones that are easiest to answer. So, so the administration can't just take back a decision that was made through a rulemaking. The rulemaking process is a complex process. It involves a lot of agency staff work to develop what's called a proposed rule, and that proposed rule comes with a very deep record by that it justifies the rule based on information that agency staff has, and pretty detailed justifications of what the scientific and policy basis is for the rule. That then has to go out officially for public comment. There are typically commenters from industry, from environmental groups, from experts of various types, from states. Those are taken and used by the agency then to consider amendments to the proposed rule when it issues a final rule. And almost, the vast majority of important federal agency actions are done through what's called notice and comment rulemaking. The only way that an agency, that the president can revise a standard that's set through a notice and comment rulemaking is through a new round of notice and comment rulemaking. So it would require a full new administrative process to do that. On the other hand, it's also possible that a court could make a decision striking down the rule. And the government's refusing to defend a rule, especially very late in the challenge, is more symbolic than anything else, because the court often, in most of these cases, the court has the record and has briefing in front of it. And essentially what the government is saying is, court, don't make a decision about this, because we're going to go back and consider whether to do a new rulemaking and create a different standard. And so it isn't instantaneous. It can't be done by fiat, by the president or the EPA, but it starts in motion a set of procedures that could result in that. And the other thing that it does is it could, in some cases, forestall a court decision that might, for example, say, yes, not only was the Obama administration empowered to create this rule, it was compelled to create this rule, which would be something that the new administration wouldn't want, right? And so that's really what's at stake here. The other dynamic is that in most of these cases, there are environmental advocacy groups that obtain intervener status, which means that essentially they're saying, we want to be parties to this case because we believe that whatever the government does to defend this, we have a different perspective that also should result in you supporting this rule. And so in most of these cases, we have intervener defendants who, in theory, might be able to pursue that. But what the strategy that the administration now has pursued in most of these cases is to file a motion to the court, essentially saying, court, hold this proceeding up. Don't rule on this. We're going to figure out what we're going to do. We might do a new rulemaking. Eventually, we might ask you not to rule on this at all. It would be a waste of the court's resources to rule on this because you'd be ruling on a standard that we're going to decide is going to be revisited. And often courts will take them up on that because courts don't want to issue a decision on something that's hypothetical or unlikely to be implemented or likely to be revised very soon. But we don't know yet what the courts are likely to do. At this point, courts are sort of holding on to it and saying, okay, we're going to wait and see. Dick?
Sean, you always hear about the court, and this court decided this, and this court. They go to the Ninth Circuit, and they'll take a very different opinion than the one in Richmond. And when you say the court decided,
Right.
does the government then shop for the
That's a great
judiciary
question.
that is the most friendly to their position?
It's a great question. So the answer might be yes in many types of cases, but the Clean Air Act is different. The Congress under the Clean Air Act gave review only to the DC Circuit for many of these types of actions. And in fact, for many of these actions, it's not even the federal trial court or the district court. It would go immediately to the DC Circuit Court of Appeals, which hears any challenges. And then the only possible review of that is to the Supreme Court. So while you're correct that in many contexts, either the federal government or some other party might care a lot about which court that something is heard in, and they might believe they're going to get different decisions in different courts. That's least true in Clean Air Act cases, interestingly. So we'll see over time how this all plays out. I wanted to talk a little bit about some of the more specific initiatives that have been done on climate change and how they're faring. So the Clean Power Plan, which many of you might have heard of, is a set of rules under Section 111 of the Clean Air Act that governs what it's called is emission standards for existing sources by category. And the idea behind what's called Section 111B, Section 111D of the Clean Air Act is that the EPA can take a category of sources, in this case electrical generating units, and say, we believe that there's a set of emission standards that ought to govern this type of source, and we're going to develop standards for certain pollutants from those types of sources. So you can imagine from something like a cement plant, it would actually be relatively straightforward. What the EPA would do is it would figure out what are the kinds of air emissions that come from a cement plant, and how should they be controlled in order to make sure that we're protecting public health. And it could set forth some pretty detailed standards that would govern what kinds of emissions can come from cement plants and how they have to be controlled. For electrical generating units, it's much more complex than that, in part because the EPA and most people who look at electricity generation see the electrical generation grid as one large system that is interconnected. And so while you could impose standards for greenhouse gas emissions on a particular coal-fired power plant or gas-fired power plant, it makes a lot more sense from the perspective that EPA has adopted and from the perspective of a lot of environmental advocates to instead look at the whole set of emission sources and figure out what are the ways in which we could substitute for gas or coal in the power sector that would overall reduce emissions of greenhouse gases. And that's particularly true in the case of greenhouse gases for one reason, which is that with most pollutants from most sources, the source is emitted from a particular point, and it matters a lot what that point is, because whoever lives or works closest to that point is going to get a certain level of emissions that come out of the smokestack that may impact their health in some way. But for greenhouse gases, the danger of emitting carbon dioxide is a global danger. It is a globally mixed gas. It doesn't matter, in theory, whether you emit them in one state or another state, in one city or another city. So the theory behind the Clean Power Plan is to look holistically at the electrical grid and say, what standards should we adopt to reduce greenhouse gas emissions from electrical generation? It was a very controversial plan, and it's been challenged legally, among other reasons, because of exactly what I just said, that one of the arguments that the industry makes is that the whole point of this is to regulate particular plants within their fence line, and that in this case what we're doing is blowing apart those boundaries in a way that they believe wasn't contemplated by Congress and is outside of EPA's authority. So that challenge has been fully briefed in front of the DC Circuit, and there's a related rule on new coal-fired power plants and gas-fired power plants that essentially for coal, for example, would require all coal-fired power plants to reduce their carbon dioxide emissions to a level that could only be achieved if about 40% of all of the emissions of carbon dioxide were captured and sequestered in some way. So it would make it unrealistic to build a new coal plant unless you had carbon capture and sequestration as part of the generating unit. So both of those rules are the subject of hotly contested litigation right now. And the EPA, unsurprisingly, went to court and said, why don't you hold off on this? Let's hold these cases in abeyance. meaning don't do anything with them while we review these rules and figure out if we are, as we think we're likely to do, going to substitute new rules for this, or maybe decide that we didn't need a rule in the first place. And the court now has adopted a 60-day reporting calendar where it's holding off. Literally, the arguments the argument in the Clean Power Plan case happened months ago. Many people expected the court to have already issued an opinion. It may have been ready to issue an opinion, but it hasn't. Instead, it's holding on to the case. And the argument in the companion case on new power plants was set to have oral argument in April, and that argument was canceled as a result of this. So everyone's waiting to see what the new administration does. And I'll talk a little bit later about some of the dynamics around that within the EPA. So we also have mobile sources, and in particular, I'll talk a little bit about automobile emission standards for greenhouse gases. Greenhouse gas emission standards for cars are really unified together with fuel economy standards, because the way in which you reduce greenhouse gas emissions is by reducing the amount of fossil fuel that's actually burned. They're not precisely the same thing for a variety of reasons, but in a large sense they correlate with each other, because unlike other pollutants, the pollution, the emissions of carbon dioxide are precisely related to the fuel that you burn. And so if you drive a car that gets 60 miles to the gallon, you are emitting many fewer greenhouse gases than if you drive a car that gets 30 miles to the gallon or 20 miles to the gallon. So in the early days of the Obama administration, there was a multi-party negotiation among the state of California, the federal government, and automakers in order to try to deal with some of the challenges that these standards were posing and some of the complaints that automakers had at the time about California's standards. California has special authority under the Clean Air Act. It's the only state that has this to regulate automobile emissions, air emissions, separately and more strictly from the federal government. With stationary sources, actually, like factories, states can do that whenever they want. Any state can decide it's going to regulate factory air emissions more strictly than the federal government does, but not with car emissions. You can imagine if you're an automaker, you don't want to have 50 different states with 50 different cars that you would have to build with different engines. But they do have to build 2 different kinds of cars with 2 different kinds of engines if California standards deviate. And other states can opt in to California standards. So we have about a dozen states that have adopted California's auto program. And anyway, in the early days of the Obama administration, there was this multi-party negotiation, and I think part of the dynamic of it was the leverage that came with the auto bailout at the time. If you recall, American automakers were in very terrible financial condition, and they negotiated a plan that would create a fairly aggressive set of automobile greenhouse gas emission standards and fuel economy standards through 2025. And with the Trump administration, that has changed. The Trump administration wants to review these standards and possibly not go forward with the standards for 2022 and beyond. Some of the auto companies at least seem to be on board with that plan, and it's unclear how that's going to work out in the end. California, for its part, has said, well, we intend to stick with these standards, and there is the prospect that in order to regulate more strictly than the federal government, California has to get a waiver from the EPA. The federal EPA has to say, yes, we agree, California, that you have compelling and extraordinary circumstances that would allow you to regulate more strictly. They have almost always said yes to that question. They're supposed to defer to California's own determination of it, but there's some thought that a Trump administration might decide, no, we're not going to let California do that. And then that would go to court because California would sue and say we have the right to promulgate our own emission standards for cars. A lot of work for environmental lawyers in this administration. There's a few other aspects of climate change that are quite affected under the current administration. I'm just going to briefly go through a few of them. They've postponed energy efficiency rules. Some of us believe this is the oddest thing that they've done. They're voluntary standards, like the Energy Star program. They are standards that seem to only have benefit and not cost to industry. And so it seems, it seems like it's more of a message than it is a policy in a way from the administration. And it will have a serious, or at least potentially might have a serious impact on on moving forward with energy efficiency, because companies really like the Energy Star program, and they often develop new products to meet those standards. The EPA is also reviewing methane rules for new and modified oil and gas production facilities on public land. So I talked about this briefly a little while ago, that our federal lands have a lot of fossil fuel production on them. Historically, much of our coal and natural gas and oil production has been from federal lands. Our public lands are used for a lot of different things, and this is certainly one of them. Aside from issues about the leases themselves that allow this extraction to happen, for the first time, the Obama administration developed a set of rules to stop fugitive methane leaks from this type of production. And it turns out that's a pretty serious contributor to climate change. Methane is a very potent greenhouse gas, more so per unit than carbon dioxide by many times. And often you get leaks of methane from production facilities, and they're not accounted for, much less regulated. And so those rules are likely going to have the brakes put on them by the new administration. Beyond that, we have both the Keystone Pipeline and the Dakota Access Pipeline decisions, both of which came very late in the Obama administration, being reversed. So on what you can think about as the supply side of oil, as opposed to the consumption side, which we were talking about in the last slide, you have a pretty major change in federal policy. We also have the opening up, or the likely opening up, of various marine areas and likely terrestrial areas also for oil drilling in ways that are more robust. Although I will say in the Obama administration there was plenty of drilling, but I think we'll see more. And towards the end of the Obama administration, there were a lot of protections that were created that are likely to be rescinded. The big question as of a half hour ago was, are we going to stay in the Paris Agreement? The answer seems to be no. The Paris Agreement is an international agreement where countries make voluntary commitments to reduce greenhouse gas emissions. A lot of different perspectives on this. I have a colleague, Ann Carlson, at the law school, who has written a series of posts on our faculty blog about this, which I suggest to people. The case that she makes is basically that it doesn't make any difference if we stay in the Paris Agreement in terms of our emissions, because all the stuff we already talked about, all these things are what is going to determine our emissions going forward. And so, if we don't take action to reduce greenhouse gases, the fact that we have theoretically stayed in the agreement isn't going to matter. And her way of looking at it is that we might be better off, in a sense, out of the agreement, because it will create more public outcry, more pressure, and the fact that the U.S. will be an outlier internationally might actually have some benefits, whereas if we gave lip service to the idea that we were staying in the Paris Agreement and didn't make any of the commitments, we would still end up in the same place. She says it better than I do and provides a lot of detail. Our blog is called Legal Planet. She posted today a post that collects her last 5 writings about this that are all really worth reading. So read that and see what you think. It's not good news. It's called Legal Planet, legal-planet.org. If you Google Legal Planet UCLA, you will find it. Yeah.
So we have joined Nicaragua and Syria.
Yes, we have joined Nicaragua and Syria. I think Nicaragua said that it didn't find Paris stringent enough.
Right.
Yeah, I mean, so, to me, this isn't an environmental question. This is, one example of a multitude of ways in which the United States has decided that we're going to go it alone and break international commitments of various types. And so, to me, it's very consistent with the positions that he's taken on NATO Article 5 and other types of issues, where they don't seem that interested in maintaining the types of treaties and alliances that we have taken for granted. I think what this means is, at least in terms of concept, we will see countries like China become ascendant and look to globally for their leadership on these issues as opposed to the United States, I think many people fear that it's going to have implications for the growing job market in alternative energy here in the United States. It can't be good for us in terms of our energy future, in my view. Again, though, on the other hand, it's really the domestic commitments and rollbacks of those commitments that will be driving that, because that's the policy. The Paris commitment is the international commitment that, that engages us with other countries about what we're doing. So I'm going to shift gears a little bit and talk about one example of public lands and natural resources. I'm including this in part because it's something I've personally been working on. There's this odd federal law called the Antiquities Act that was passed in 1906 when Teddy Roosevelt was president that allows the president to reserve lands from out of the public domain and say that they can only be used for certain types of uses, typically preservation of scientific or historical objects of interest, which has been interpreted since the earliest days to include natural features. So in 1908, Teddy Roosevelt reserved 800,000 acres for the Grand Canyon National Monument, which eventually Congress made into the Grand Canyon National Park. And there have been many, many examples of the president reserving national monuments and then Congress ultimately creating national parks out of them, including Joshua Tree and Death Valley and Grand Teton and the Grand Canyon, among others. And it's an interesting act because, it doesn't involve an administrative agency. And 95% of things that Congress has delegated to the executive branch, it names an agency. It says the EPA administrator shall do this, or the Secretary of Interior shall do this. Here it's the president. And it gives this odd power to the president to, with the literal stroke of a pen, to issue a proclamation reserving lands. It's been used a lot over the last 100 years. The last two presidencies have used it for the first time to create really massive marine monuments. Both George W. Bush and President Obama have done that. The idea behind this, is to create a kind of authority in the president that you can imagine President Roosevelt having been very motivated to use at the time. And it really has been something that advocates of wilderness and preservation and outdoor recreation care a lot about, because we have much, much land that's in the public domain that isn't protected in this way. So it's open for mining claims and oil and gas production. Other types of resource extraction. And national monuments can be a way of removing public lands from that type of resource extraction going forward. So this is another area where President Trump has set his sights on reversing what prior presidents have done. He issued an executive order ordering the Department of Interior to do a review of the last 20 years of national monuments, going back to 1996. And those national monuments are going to be reviewed with an eye, it appears, to trying to downsize or abolish them. And this is an open legal question whether presidents have that power. I just co-wrote an article that makes the case that presidents don't have the authority to diminish or abolish monuments. That article has gotten a lot of attention recently because of its timing together with this executive order, and it's been interesting to be part of the debate over that. It's very complex. It's another instance where the statute itself was vague. It didn't address this question directly. There have been presidents in the past that have diminished the size of national monuments. We believe that was improper for them to do it. It was never challenged in court when it was done. And a president has never abolished a monument. The way I look at it, a president can do that, and then it's in Congress's hands. Congress then can decide to make the monument into a national park, or it could decide we didn't want you to reserve this. Let's get it back into oil and gas production. And Congress has the power to do that. But we don't believe that. We believe it's a one-way authority for the president to reserve and not to take back. Christina.
So the first step is to become. I'm sorry.
It's okay.
Is the first step Yosemite became a national monument, and then by law, congressional decision, it became a park, And does that have a more protected status than?
That's a good question. So Yosemite isn't one of these. Yosemite has this even stranger history. But so let's take Joshua Tree. So yes, so what happened in the case of Joshua Tree is that the president declared, I forget which president it was, declared a national monument. It became reserved from certain types of uses as a result of that. It was managed as a national monument. I don't know which land agency managed it, but typically it would be the Bureau of Land Management that manages it. At some point, there was an act of Congress that said, Joshua Tree will be a national park. That changes who manages the park, in most cases, to the Park Service, which has a slightly different culture from some of the other land management agencies. And it can also change the protections, because the Park Service has its own set of statutes that govern the way that national parks are governed. In many cases, the on-the-ground results of it might not have been much different. It really depends on the particular monument. But I think the idea is that national park status feels more permanent. You know, even though a national monument can continue indefinitely, typically national parks get more resources devoted to them, you know, because they become individual units of the Park Service. But the technical difference is that one of them is proclaimed by the president and the other is designated by an act of Congress. Christina, do you have a question?
It's related to this, sort of an executive order to roll back regulations that was a similar one that was made by the president to the EPA.
Mhm.
And then they did open a public comment
Mhm.
period. Are you familiar with this?
Yes.
Which regulation should they do away with?
Yeah.
Which monument should we do away with, kind of thing. And there were it's an outpouring, like 55,000 comments, the majority in
Yes.
support of the existing regulation. And I'm just wondering, is there any legal precedent that they have to follow those comments based on the past, or can they just disregard all those comments and go away with slash and regs?
That's a great question. So there's no legal requirement that they have taken these comments at this point. Now, if they do choose to amend any particular rule that's out there, as I said before in answer to Brian's question, you do have to do a new rulemaking to do that, and that rulemaking will have its own public comment period. I tend to think it was a misplay on the part of the administration to take these public comments because the overwhelming number of them numerically is going to be on the environmental protective side. But you never know, and particularly with national monuments, there are constituencies, especially in Utah and the Intermountain West generally, that are very much against creating national monuments. I don't know why they decided to do it. I don't know that these comment periods have any particular legal significance at all, but people are commenting. I think it'll be interesting to see that. In an actual rulemaking context, comments matter because the agency has to take the comments into account and respond to them in some way, even if it's generically. In these cases, I think it's much less clear what they're after. And we are still in the middle of the comment period on national monuments. I'm happy to send around a link to the docket on that if people want to make comments. Our Legal Planet blog, which I mentioned, also has a set of posts on this, including some by me, that link to the article that I wrote and to some other materials if people are interested. But it is a good question. What's the value of all these executive orders that are asking agencies to do things? And I don't know the answer to that. But that actually segues really well into what I wanted to talk about, I guess, from my final talk. Well, it's not quite my final talk. I wanted to get to California. I'm not going to talk about California at all, but I will talk a little bit about the way that federal agencies are responding to this. So as you can imagine, most of the staff in federal agencies care about the mission of their agency. They're scientists or managers who have they're in the work that they're in because that's the kind of work they've committed themselves to do, and they care about that work. And you can imagine that in an environment like this, it's very difficult for those employees to feel like they are actually executing their mission. And so, you have to see some of these actions with that in mind as well. There's some staff person at the Department of Interior or at EPA, in the case of the EPA rules, who's sorting out all of these comments and, has been asked to make recommendations about what changes to make. You can imagine that, there are morale issues that come with this. I think we're going to see an exodus of employees from some parts of the government. There are definitely policy issues that come from this, where agency staff are being asked to do things that seem to not to be at odds with what they understand the mission of their agency to be. And there are also legal issues. And the example that I have in this slide is what's often called the 2-for-1 executive order. It's this executive order that would require the repeal of 2 regulations for every new one that's adopted and no net increase in costs for new regulations on an annualized basis. And we understand that no increase not to be even an increase of the net of costs against benefits, but simply looking only at the cost side of the ledger. And so, you kind of wonder, how could that even be possible mechanically and legally within an agency to develop new rulemakings that repeal 2 rules before you can then start a rulemaking on another one that, it's hard to even imagine, like if you're an agency staff counsel trying to advise an agency, how do we comply with this executive order and still comply with the law? It's difficult to imagine what they have to navigate in order to do that. Even if they believe that it was a good idea. So, there is quite a bit of thought that, many people within these agencies are not going to be very effective at doing what they're doing in this environment. Some of them may intentionally be ineffective at doing what they're doing, but even if they're trying, I think, in a sense, one of the good news, I suppose, for environment and health might be that it's going to be a very long, slow road to actually undoing most of these regulations. I think the really bad news, though, is that we're going to be draining the civil service of a lot of the talent that we need in order to accomplish the work that needs to be accomplished. And we're also going to be delaying action on climate change with time that we don't really have, that's going to be wasted over the coming years. But I do think it's unlikely most of these initiatives are actually going to move forward very quickly to the extent that the president actually has to take affirmative action moving forward. On the subject of the drain of talent, some of you probably have heard that there's also been personnel changes at the science advisory boards within federal agencies, and there's talk of replacing career scientists, academic scientists, with people who have a relationship with industry. And obviously the whole point of the Science Advisory Board is to have independent people reviewing these types of actions. So, again, at the end of this administration, if we were to see an administration come in that were committed to the missions of these agencies, they would have to pick up a lot of the pieces to try to figure out how you remake the agency. And so I think that's the real danger going forward. Very quickly, just, this is budget proposals. The draft proposals don't look very good, to put it mildly. This is Department of Energy. You can see the massive decrease in energy efficiency and renewable energy programs, massive cuts in EPA and NOAA science funding. The current budget, I think, still has a proposal to eliminate the Sea Grant program at NOAA, for example, entirely. So there's a lot in there. And I have 0 minutes to talk about California, but what I will say is that California's legislators and the executive branch, the Brown administration, have articulated very strongly a commitment to being a backstop against federal backsliding. One of the huge issues that will come up will be preemption, because Congress does have the authority to stop states from regulating more strictly than the federal government. As I mentioned at the very beginning of this talk, there's often a lot of ambiguity about where those boundaries are. And so there are always legal arguments where it's unclear what the boundary of a legal doctrine is. So it looks like I am at the end now. Thank you, everybody. Happy to engage with all of you.